Hey everyone, Dan McKenzie here with the McKenzie Law Firm. We are an estate planning, estate administration, and small business counsel law firm in the Denver, Colorado area. I want to make a video today talking about spouses serving as co-trustees with each other on trusts that we set up for them. Usually we're talking about revocable living trusts. And maybe a first issue to discuss before getting into that is how those trusts are set up. Are they set up separately with each spouse having their own trust, or do we set up one joint trust for both spouses? And so we find that a lot of people who come in actually expect that there be one trust and are kind of surprised to find out that there might be two separate trusts. But in Colorado, we are a separate property state, which means that property acquired during marriage is not necessarily presumed to belong to both spouses. You can acquire property with your own funds and keep them titled separately, and even if you're married, those assets are separate from one another's. The alternative possibility is if you live in a community property state, and that's most community property states are kind of West Coast states like California and Oregon and Washington, and Arizona and Texas sneaks in there, and actually Wisconsin too. Strangely, Wisconsin's kind of the only exception to that West Coast thing. But otherwise, those states, property acquired during marriage is presumed to be community property, owned entirely by both spouses together. And so that's not our presumption here in Colorado. So what that means is we probably have a little bit more flexibility as far as spouses keeping assets separate, and we do so in a lot of circumstances. There are some real advantages actually to titling things separately to the two different spouses and keeping them with two separate trusts. Now, I will quickly say that community property states have a big advantage as far as some capital gains tax benefits that are kind of beyond the scope of this video, but it's not. There's some real advantages to being a community property state. Anyway, for purposes of this video, whether we set up two separate trusts or one joint trust, usually both spouses are trustees for either both trusts or the joint trust. And sometimes people do ask us about that, like why would we set up separate trusts and have us both be trustees? And in a lot of circumstances, this actually is pretty nice, and it's actually a big advantage over when they have assets titled to themselves separately. So a very common situation we run into, as an example, is where they have a house, but really only one of them is on that deed of that house. And the frequent explanation for why that happens is like one had a much better credit score than the other. So as far as securing their mortgage, it just made a lot more sense for the one with the credit score that was better to be the owner of the house. But that can be very precarious, because what that means is the person who's not on the house might actually have to go through a probate process to receive their own house if their spouse who owns the house passes away. So most people certainly don't want that. And there are, if you have separately held property, you cannot presume that a spouse can go in there and deal with that property. So let's say the spouse who owns that house in my example gets injured in some way that causes them not to be able to deal with the house anymore. Like they can't go to a closing, they can't sign documents, they can't refinance the house, right? They're in a hospital recovering from some sort of accident. And what can the spouse do that is not on that property? And again, when I moved out here actually to Colorado, I got here a couple weeks before my wife, and I had to get power of attorney from her to be able to sign our closing documents. They weren't just going to presume that because I was her husband that I had that authority. We needed written documentation. So, of course, many couples don't have that, and they kind of presume that even though the house is held, that was just for some sort of financial reason, but they're both owners of it. But that's not how the finance companies look at it. That's not how the clerk and recorder's office looks at it. So, putting that property into a trust, maybe for the spouse who was the original owner, so it's still under, their name for all intents and purposes. But now the spouse who was not on the ownership of that house is a trustee of that trust. And this actually gives them more authority. We can say in the trust document, either spouse can sign on behalf of this trust. They don't both need to do it. And so that can open up some real flexibility and possibilities for the spouse who was not on the property before to actually deal with it. And so a lot of couples want that. And a lot of couples do want us to say in the trust agreement, either one of us can sign for this trust. We don't both need to sign for everything. And again, that actually might make things more convenient than they were before when you had stuff titled in your own names. Again, going back to my example, when I was signing closing documents for my wife, if we were signing on behalf of a trust that I was a trustee of, we might not have really needed to get written authority from her. We could have said that in the trust agreement. And so, and then of course with a joint trust, I can't think of too many circumstances where people would want a joint trust but only want one of the spouses acting as the trustee. That would be kind of a weird situation. But with separate trusts, a lot of times it really makes sense for both people to have control over all assets, even if they're titled separately. So that's why we do that. And we do get a lot of questions about the joint and separate trust thing and who should be trustee of what and what kind of signing authority. I should say we have had couples who do not want to set it up so that they can both sign alone. We do have couples who say, no, we will both be trustees of this trust, but we both want to sign. I don't want my spouse signing on behalf of this thing without my knowledge necessarily. So you can do that. You can say that in the trust agreement too. So hopefully this helps, and I appreciate you watching all the way through. And if we can be of any help at all, again, we are the McKenzie Law Firm in Denver, Colorado. Our phone number is 303-578-2745, and thank you.